this afternoon. Um, Kelvin, I sent you a short message. Please just check. Right. So, I know it's a Friday afternoon, almost evening, and I assume that a lot of folks are, just trying to wind down for the weekend. And so I applaud the fact that regardless, you all have joined to be a part of this conversation, right? So I guess I will share my screen as I start to talk. So I'm sharing now, and then if you all can confirm that my screen is visible. Yeah?
Correct, sir. We can see
Good,
your
good.
screen.
Okay, fantastic. Fantastic. Okay, so our topic for this session is online dispute resolution. I'm aware and I know that very distinguished speakers have come before me and have taken us through the nuts and bolts of ADR, different parts, the substantive part. And I know that after me, there are still more to come. So perhaps it would serve no useful purpose to try to reinvent any wheel here. And that's why I will be laser focused on the aspect that has been assigned to me. I want to thank Dr. Tolu and the entire team for this privilege and counting me worthy of this platform. I hope that the next couple of minutes will be impactful and we all will um, have a reason to remember that we gathered today. So again, online no. Alternative dispute resolution, ADR. Of course, its component parts, negotiation, mediation, arbitration, and however much more you have already been taught here during the course of the past 7, 8 weeks. These are tools of our trade as legal practitioners, as lawyers. They are essentially processes for resolving disputes without going to the regular court. Like you have already learned, ADR is essentially faster, more flexible, more cost effective, presumably. And you all are here because definitely you are interested in ADR. And quite frankly, that is the right starting point. Um, Now, what happens when you take these same ADR processes and you move them online? When you take the same ADR processes that you are already familiar with or you are learning about negotiation, mediation, arbitration, when you take them and move them online, well, that's what it is. Online dispute resolution, ODR. So ODR at its heart is just ADR for the digital age. Let me say that again. ODR, online dispute resolution, at its very core, simply put, right, is the same ADR but adapted for the digital age. Now, the reason why you see that my focus today will be AI assisted dispute resolution is because The world has moved or is moving from the digital age to the intelligence age. And of course, AI is artificial intelligence. So if ODR is movement, right, of ADR to the digital age, then perhaps it suffices to say that we could as well move ADR to the intelligence age. And that's why my focus today will be AI assisted dispute resolution, which is an abstraction over the digital age that you already know. Okay, but whether we say digital age or we say intelligence age, again, the DNA is technology, right? So ODR uses technology to facilitate dispute resolution, right? And these were processes that were traditionally conducted face to face, whether in a boardroom or in a hearing room as it relates to ADR. Again, the processes are the same. I will continue to repeat this. Negotiation is still negotiation. Mediation is still mediation. Arbitration is still arbitration. What changes is the medium. What changes is the infrastructure through which these processes are now being delivered. So let me be clear. ODR, online dispute resolution, does not replace ADR, right? Rather, it is the natural, inevitable evolution, right, into a world where business, commerce, conflict resolution no longer require everyone to be in the same room at the same time. By the way, let me give a caveat here. So my caveat would be, you would observe that the things I am talking about now, it applies to traditional dispute resolution, which we call um, um, litigation, right? As much as it applies to ADR, the alternative dispute resolution. So just open different tabs in your mind as I continue to speak. That yes, when I say that ODR is the natural evolution, moving ADR into the digital world or the intelligence age, you can connect it to litigation as well. So um, anyways, our focus is ADR, but some of the things I'm saying would apply to litigation is what I wanted to establish, right? So what are we going to cover today? We will trace the movement of the evolution of ADR itself, right? From ADR in its simplest form to AI-driven dispute resolution, which is still ODR, right? Then we will look at the global landscape. Who is doing what? What country is doing what? Then I will now go full scale into the AI-driven ODR. And then we'll begin to look at what AI can actually do today in terms of ODR. Then we will look at the risk, the governance, and the ethical lens. And then we will look at what this means for your own practice, whether you are already neck deep in arbitration or you are looking at exploring that frontier. And then we will talk a bit, if time permits, about the different nuances that applies to places like we are in Nigeria. And then we will look at a framework for responsible adoption, a framework for responsible ODR adoption. But in this case, AI-driven ODR. So let's think about the problems that traditional dispute resolution faces today. I think the first one is cost, right? And when I say traditional dispute resolution, now I am straddling this first one, cost. I am straddling between litigation and ADR. But let's even look at ADR itself, the commercial arbitration. I'm sure you know that it can actually cost parties hundreds of thousands of dollars in legal fees, in arbitrator fees, in venue costs, in travel. So when we say DR is cheaper, it's a relative thing. All right. It's cheaper because in the long run, it's faster. And the years you probably have been tied up in litigation, you skip all of that in arbitration. But there's a cost factor. So these are the I'm talking again about why ODR exists, cost. And of course, for many smaller disputes, the cost of the resolution, exceeds the value of the dispute itself. Think about a simple thing like you erroneously transferred money to some third party by mistake. And then you approach the bank, and the bank says, well, you need to come with a court order. And then you are thinking, a court order, seriously? How much are we talking about here? I erroneously transferred 20,000 naira or 50,000 naira. If I were to get a court order, I would hire a lawyer. I am not sure that you will get a lawyer to represent you for 50,000 naira. So, in many small disputes, the cost of resolution exceeds the value of the dispute itself. Number two is delay. We know that, let's look at litigation. Nigerian courts are notoriously caught in this. As at today, some 200,000 unresolved cases. It is 200,000 plus, right? So commercial disputes, as you know, can take more than 5 years. Land disputes, 10 years, 20 years, especially if it goes on appeal. By the way, it's not unique to Nigeria. Court systems all over the world are overwhelmed. Now, geography is another issue, right? Think about a supplier in Lagos or in Lagos and a buyer in London. Should you have to travel to a third country for a 2-day arbitration hearing where you supplied, or let's reverse it, a supplier in London and a buyer in Lagos, you bought an iPhone. Yes, and then it had a broken screen. Do you have to travel to Singapore to um, 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 go before an arbitrator to resolve that dispute? I don't think so. So, I mean, essentially, ODR was created to address all of these three challenges: um, cost, delay, and geography. And how? By moving dispute resolution online, you reduce costs, you accelerate the timelines for hearing, and then you make justice borderless. All right. So this takes me to um, the next thing I want to focus on this evening. I hinted at it initially, and that is the three generations of ODR. So ODR has evolved through three distinct generations. And it's good that you understand that evolution so that you know why we are where we are today. So the first generation was roughly between the year 1996 and 2010. Well, what happened during the first generation of ODR? We had what I would call digital post office. What do I mean? For those who remember the early days of the internet, when e-commerce first came when e-commerce first became a reality. You would remember marketplaces like eBay, right? Um, Amazon was not even a thing then. I think eBay was the biggest marketplace. And the things that you do now on places like Amazon were the things you did on eBay. So, and of course, one thing that was very unique to this e-commerce site was that the value of most of the transactions were very low value, right? And so the issues that we had discussed before now as to why ODR was very significant in that space. You really could not go into the traditional dispute resolution space to resolve disputes such as what I bought was not what I got. This what I ordered, this what I'm getting. No. And so these marketplaces, these online marketplaces like eBay, they actually put in infrastructure. The infrastructure was just like a kind of email paper-based negotiation process. So the technology was email and web forms. It was efficient and it resolved many of the issues. So essentially, the disputes were resolved by the buyer sends something like an email or uses a web form. The seller does the same, and then the system was like a software, was just like a communication system that facilitated dispute resolution, right? And it was no big deal. Definitely, it had no intelligent system attached to it. It was just basic infrastructure. And the next generation was within the year 2010 to 2020 or 2022, right? So that was the time when genuine infrastructure was now added. And it was at that time that the EU launched an ODR platform for online consumer disputes. Indeed, British Columbia built the first online tribunal also at that time. And that continued and it evolved into the COVID era. Now, again, the COVID era was when human beings, started to take technology much more seriously. It was forced, it was a result of circumstances, but that was the era of Zoom. And in fact, traditional dispute resolution, like the litigation, the traditional court system, jumped on the train. There was now virtual hearings. Different courts started to issue practice directions for virtual hearings. So essentially, what happened at that time was the barrier, legal practitioners are traditionally conservative. So what happened at that time was that the barriers was lifted. Then lawyers realized that, oh, the walls did not fall if we went on Zoom to resolve disputes. We did not have to be in a physical courtroom. And ADR, which already was kind of more flexible, adopted and embraced virtual hearings even more quickly, right? So that was generation two, 2010 to 2022, right? But then came what I call the third generation, generation three. Generation three, ODR, right, was what I would say started from about the year 2023 to the present day. Now, something fundamentally different began to happen. And for those who are being mindful of that time frame, you know that consumer AI, consumer artificial intelligence, became mainstream in November of 2022. That was your chat GPT, right? Now, then AI became a thing. Now, AI had already existed from the 1950s, but AI at that time was pretty much deterministic AI. It was not the generative kind of AI. The generative kind of AI kicked off in the year 2022, in November to be precise. What happened? AI systems stopped becoming just tools for personalization, tools for customization, tools that the likes of Uber would use on Google Maps, or the likes of Netflix would use for movie recommendation. AI systems now became tools for process management. And it went a step further. AI tools started, performing substantive analytical and evaluative functions. Let me break it down. It meant that we now had computer systems that can read evidence. We had computer systems that can assess arguments. We had computer systems that could model and predict outcomes. Now we had computer systems that could even draft decisions, right? So now you see why I took my time to take us through the three generations of ODR, from the very basic process-driven ODR to the more robust, technologically driven ODR, to the now cognitive and intelligence-driven ODR. That's what I call we are in generation 3. That's where we are today. And that is why I am taking this session from the traditional ODR, and I renamed it AI Assisted Dispute Resolution. Before I go on, I still have a lot to say. I want to be sure that you are following me. And so maybe I could pause for anyone to just make a comment and let me know that you are with me before I keep going. I'll pause a while.
I think we're with you.
Thank you very much, Benjamin. Thank you very much. Okay, so before I go into the geopolitics, let me shock you a little bit. Well, not shock you, but let you understand what I mean by generation 3. If I told you that right now, as we sit here, an artificial intelligence system is reading construction arbitration files in the United States, it is analyzing evidence, it is applying legal reasoning drawn from over 1,500 prior awards, construction awards, and that this artificial intelligence system is, as we speak, drafting arbitral decisions. Would you believe me? Well, I wouldn't know what your answer would be, but can someone offer me an answer? Would you believe me? All right.
What is the question, sir?
So the question is, if I said to you that as we sit here today, there is an artificial intelligence system giving an arbitral award as we sit here, would you believe me? That's the question. Any response?
Well, I'll believe you because the world is a village now, and most things are instantaneous these days.
Okay, thank you very much.
Just like you're taking just like you're taking us on this session, I think it's seen all over the world as long as somebody keys in. So
Fantastic.
it's almost the same thing with all this AI thing. So if anybody is sitting anywhere in the world, he can listen to Mr. Rotimi Ogunyemi instantaneously. So I guess the same thing will be happening.
Thank you,
all,
sir.
right.
Thank you, Doc. Thank you so much. So yes, the reality is that it is not a concept. It's not a pilot, just a project somewhere. No, this is a live commercial deployment by, guess who? The American Arbitration Association. This launched in November 2025. It's called the AI Arbitrator. It is operational as we speak right now. Cases are being resolved through it as we speak right now. And I'm going to tell us a little bit more about it as we go on, right? But let me take a step back and just give us a snapshot of where the world is, just generally, and I would go further. So maybe we should start with the US, where this AI arbitrator actually sits. What's going on in the US as we speak? This AI arbitrator, now let me give you some details. The American Arbitration Association, working with an organization called Quantum Black. Now, Quantum Black is the AI arm of McKinsey. You all know McKinsey. McKinsey is, this intelligence-driven professional services organization. So Quantum Black is its AI division. Quantum Black built an AI system that was trained on 1,500 plus actual construction arbitration awards, not hypothetical scenario, real awards with real arbitrator reasoning, right? And so this specialized AI system was trained in construction matters only. And for those who know construction matters, it is highly specialized, it is high volume, and it is a very technical area. You are looking at myriads and myriads of pages, if not hundreds of construction agreements. You are looking at design drawings of multiple hundreds of pages, depending on the scale of the construction project. You are looking at several change orders, things happen. You are looking at everything that could go right or go wrong. Take Nigeria as a case study. Any construction project, take Lagos Ibadan Expressway, see how many years it took, see how many things came in the way. So, I mean, for this AI system to be built just for construction related cases only tells you that the American Arbitration Association, we are intentional. So what does the AI system do? It reads the case files. It analyzes the evidence. It applies patterns from its training data, and then it generates draft arbitral awards. But this is crucial. Always, a human arbitrator then reviews the drafts, with full access to all the case material. The human arbitrator will revise, will amend, and in some places rewrite until it becomes a final award. And of course, that's what we call human in the loop. But the point is, the AAA, the American Arbitration Association, right, has launched this project. And they say that part of what it has done is that it has reduced the cost of arbitration in construction, particularly by up to 50%. And as you know, construction arbitration cases are in hundreds of thousands of dollars, and that's multiple millions of naira if we are in naira. So if you are able to reduce the cost by 50%, it probably means you are saying instead of paying an arbitrator 200 million naira, well, now you would pay 100 million naira. That is significant. That is not chicken change, like we say here, right? And the interesting thing is now that they have launched that project, they are now looking to expand to other industries and to more complex disputes, right? So, and I use the US and the AAA as my US example to tell us that ODR, because that's what it is, has gone AI powered in the US, and the AAA AI arbitrator is your case in point. Now, let's look at China. China has even gone way ahead of the US because as far back as 2018, China has been an adopter of ODR in its court systems. And so you have internet courts, and I even mean traditional courts, not just ADR, in Beijing, in different provinces in China, as far back as 2017. These courts handle disputes from online transaction to e-commerce to digital services, and they use today now advanced AI for case filing, for evidence verification, even for automated judgment. And it has become routine in China, right? So it's not an experiment. It's been woven into the judicial workflow at a systemic level. The European Union, well, the EU does not have a lot of progress in this case, and I'll tell you why. Remember, I said in Generation 2, the EU actually floated the first ODR platform for e-commerce cases, but they kind of collapsed that system. And I'll tell you why. Well, it's because the EU is taking a different approach. It's taking a regulatory first approach. And when you look, for instance, at the EU AI Act, what the EU has done is to classify the administration of justice as high risk. So that means that if they were going to deploy technology, ODR, for dispute resolution, it is deemed as high risk. So it's going to pass through stringent requirements, the highest requirements of transparency, human oversight, data governance. And so bottom line is, if you wanted to deploy an AI system in the EU, you are going to jump through many hoops. It is incredibly tough, right? And you might wonder, why am I saying this? I say it because of something you've already learned in the course of this week, or which you will learn, which is when you choose your seats of arbitration. Now, it used to be that the EU, the UK, and some of those places were go-to places. But if parties begin to get the sense that the policy environment, the regulatory environment, like it is in the EU today, is kind of hostile to ODR, it's going to play a role in where parties determine the seats of their arbitration, should be. Those who know more than me should be thinking seriously about the implication of the EU being very regulation heavy when it comes to ODR platforms, and in this case, AI powered ODR platforms taking roots in the EU. pretty much that's what's going on in the world. But places like let me look at a place like where now? Singapore, UAE. Now, those places are positioning themselves as ADR hubs, right? As arbitration centers. And they are doing it because, I digress now. The war, the Iran war ongoing, has had a shock effect on places like Dubai, the UAE. And it's a shock to the world economic system. Why? Because places like Dubai has positioned themselves as the global center of commerce. Now, part of the things that has to fit into that thread is dispute resolution. If you have dispute resolution systems and processes that are reliable, then the world of commerce will flock to your jurisdiction. So you have serious inroads of ADI platforms in countries like the UAE, in Singapore, and these are becoming major ODL centers powered by AI technology. So let me then go further in terms of what can AI actually do today in ADR, right? Or better still, what can AI actually do in ODR? The slides you see on the screen, is a summary of the different ODL platforms in different parts of the world. The first one is the AAAs, and ICDR AI arbitrator. Then you have the one for smaller claims, that's the boat mediation. I mentioned the Chinese internet court. The EU is becoming even very friendly in terms of ADR. Every matter that is 10,000 pounds and below must go through an arbitration track, and much of it is now being digitized, right? So what role does ADI play? I want to quickly go through what I would call the taxonomy of functions. And there are essentially 8 of these roles. So think about it. I want to get very specific, and this is not hype. What can ADR actually do in dispute resolution today? And when I say today, I mean March 2026. Number one, it can read your pleadings, and it can automatically extract every legal and factual issue in a dispute. For those who are wondering, like, sir, are you for real? Yes. And that is at the heart of AI. AI is more than one technology. You have what you call machine learning. You have what you call computer vision, right? And between machine learning and computer vision means computer that can see. Machine learning means computer that can learn from history. And then you have natural language processing. That means systems, computers that can understand human language. It used to be that computers only understood 1 and zeros. But today, with those 3 technologies, so if you are following me, those 3 technologies I mentioned, natural language processing, computer vision, and machine learning, those 3 technologies are actually what make up AI. Machine learning means this system can look at historical records. All of dispute resolution is always about precedents, what happened in the past. This system, computer vision, means these systems can see. What do I mean? If you use the camera of your phone and you point it at anything and you ask your consumer AI, ChatGPT, Gemini, or Claude, tell me what you are seeing, it's going to start talking to you, right? And then you have natural language processing. Those three technologies means that AI-powered ODR can read all of your court processes, or in this case, your arbitration filing. It can read your statement of issue. It can organize your pleadings. It can actually synthesize it and tell you the strengths or the weaknesses of each party's position. So that means you can stress test your own facts or stress test the arguments on the other side. And then this AI platform, Generation 3 ODR, right, can actually predict what the outcome of the decision can be. Then not only that, it can do what the AI arbitrator is doing in the US. It can draft awards. It can draft settlement terms. That's why I told you this is not in the future. That's what the AI arbitrator is doing today. It can suggest negotiation pathways. It can identify possible areas of agreement. It can recommend concession strategies. Tell me everything that we do in ADR today. An AI system exists that can do it at 98% accuracy. So, the 8 things that you see on the screen are the summary of everything I have just said, right? Maybe we should go over it slowly again. The AI can function as a decision maker. It can function as a decision support tool. It can help the human arbitrator make a decision. It can also serve as a process manager, right? What do I mean by process manager? It can help you with your case. What are your typical workflows when you go through an arbitration? I don't have all the time here, but an example was I sat as counsel on a significant arbitration very recently. And incidentally, all the documents came, very quickly and suddenly, and we needed to respond. This was high volume, high value, very sensitive matter. In a very privacy preserving way, and a system that could synthesize these documents, I was able to analyze hundreds of contractual documents and come up with a case strategy in 2 hours. Typically, it would have taken a team of 15 lawyers 30 days to do exactly what I did unilaterally with 3 major AI systems in 2 hours. For those who wonder, we were very successful in that case eventually by way of outcome. Why? Part of it was because there was nothing the other side was going to throw at us that we had not already role played and synthesized on our own end. We saw every argument the other side could come with. We were ready. And we were doing it in conjunction with an AI tool. So what I'm saying is not science fiction. I'm talking about what happens today, right? So it was an arbitration proceedings, and it happened. I, for one, did not leave my location, which is Lagos. The hearings happened pretty much in Abuja. It was an international arbitration. The other side were outside the country. I did not leave Lagos, for one. I made all my inputs over Zoom, right? And I had all my tools working for those who know agentic AI, working for me on the background, right? Now, so that's the reality. The 8 things that you see on the screen: document analysis, predictive outcome, case automation are all things that an AI-powered ODR system can do. So let me give you a live demonstration or a case walkthrough. Imagine a construction dispute. Say a contractor claims that they are owed maybe $280,000, right? And then say the property owner disputes the claim, arguing that the work was within the original scope. Both sides have submitted documents, which is the original contract, change order request, email correspondence, invoices, and expert reports. Now, in a traditional arbitration, both counsel will prepare submissions, right? An arbitrator would read everything, will hold a hearing, and render an award perhaps months later. Now, think about the AAA, the American Arbitration Association's AI arbitrator model. That same AI will ingest all the documents, will identify the key issues, will cross-reference the parties' positions against the contract terms and the evidence. It will then go further. The AI arbitrator will analyze patterns from 1,500 prior construction awards, and then it generates a draft decision with reasoned analysis. Then a human arbitrator reviews that draft with full access to every document, can accept the AI's analysis, modify it or rewrite it, and then the final award becomes the human's responsibility. What's the result? What might have taken 6 months or 9 months? What might have cost each party to pay the arbitrator $50,000 each? You might now have to pay just a fraction of that amount. Like I said, that is already happening. So I think the next question will then be, and I'm sure we are all lawyers and we are already wondering, are there risks? I mean, seriously, should we be doing this? Well, the short answer is that yes, there are risks. And I'm going to dedicate the rest of the time on this call to the risk, the governance, and the broader ethical lens. So let me just pause here and hear from Kelvin. How much time do I have left, sir? Kelvin, can you hear me? How much more time do I have? All right. Okay, let me check. Okay. I think we started at a 5:15. So I will go all the way, I mean, 4:15, I'm sorry. I will just do another 12 minutes and I would stop at a 5:15, and then we'll take questions from them. All right, so what are the risks? The things that I have described. I think it's obvious that every risk that we have always talked about when we look at AI systems generally, they would now apply to ODR systems that are powered by artificial intelligence. And I think the very first risk we should look at is the risk of bias. Okay, so AI systems learn from historical data. And in the case that I have been mentioning, this construction AI arbitrator is learning from 1,500 past construction cases. And you are wondering, okay, so if the AI system can learn from 1,500 construction cases, can anything go wrong? Well, yes, some things can go wrong. Let me give you an example. Let's say that in those 1,500 cases, trial cases, real cases determined by human arbitrators, the truth is, because this AI arbitrator is learning from the 1,500 cases, directly or indirectly, it would have also learned that bias. And somehow, even though the AI is a great analyzer and a great reasoner, if it was ever in doubt about any issue, it may just skew in favor of the big time contractor because its training data, just showed that in maybe 90% of the cases, the big time developers win. So that is an inherent bias. And that's always an issue when you consider artificial intelligence as a technology. There's always the issue of historical bias. So that is one, right? How about due process? Um, all of us in dispute resolution, there's one thing that we know about due process. You want a situation where you understand how this award was made or this judgment was reached, right? So that at the very least, you can challenge it in court on appeal. But there is a particular issue with most AI systems, and that is what we call the black box issue. So, at the heart of every AI powered ODR system is mathematics and statistics. So all the results that the AI arbitrator will churn out is actually mathematical calculation and statistical computation. So even though the more advanced AI systems today can explain, quote and unquote, their reasoning, and that's why if you look at your typical chat GPT or Claude, if you are using any of its enterprise or pro version, you would see it's what it's called its chain of thoughts. You will see its reasoning. And I don't have the time to go into that, but in 2022, when the first AI system came out, it was just pure generative AI. But by 2023 into 2024, the reasoning models started to become mainstream. What made the reasoning models different from the typical generative AI was that these are systems that can think deeper. And if you use the higher grade AI, you will see this chain of thoughts. You will see the AI talking to itself, saying, all right, now I am looking at this document. And if it was an arbitration, it would say, so now I'm looking at the issues. I'm looking at issue one now. I'm looking at the party submission. I'm looking at the reasoning. I think I'm going to go for party A rather than party B. You actually see the train of thought in today's generation of AI tools, but still the AI hallucinates. And hallucination means the AI, by virtue of its inherent design, is designed to make you happy. So, because the AI by design does not have a truth database, even though in this case it has 1,500 past construction cases, if it's ever in doubt, if it encounters an issue in the case before it that was not specifically captured in the 1,500 construction cases prior, it's going to guess. And when it guesses this, it could just guess wrong. And if it guesses wrong, that's what you call hallucination.
Oh, how much? Oh, how much?
Can I go on? All right. There's also the question of accountability. Do you really and truly want a system to decide your matter? And then I think at the heart of this is also enforceability. You all know the New York Convention. I mean, that's the DNA of ADR. That's the convention. I think it was signed in 1958. That's what makes international arbitration awards, wherever it was delivered, enforceable anywhere in the world. But there's one thing about that New York Convention. It's specifically, I mean, it was drafted in 1958. There was no Generation 3 AI-driven ODR then. So it assumes that the arbitral award is being delivered by a human. And so it then means that if an AI arbitrator delivers the award, perhaps without human intervention, that award stands the risk of being challenged successfully on appeal, right? Because it might be violating the New York Convention, right? And so these are the challenges. But beyond those core challenges are also challenges around data privacy, around cybersecurity, and around um, 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 ethics. The fact that the AI can act, should it act? So let me do a quick recap. The governance issues, when you look at ODR in terms of AI-driven ODR, AI systems learn from historical data. That data reflects bias. The AI will reproduce the bias. And in dispute resolution, this could mean outcomes that systematically favor certain types of parties or claims. Number two is due process. The right to fair hearing is foundational. If an AI generates a decision, can the losing party understand why they lost? Can they challenge the reasoning of the AI system? And is the AI system transparent enough for this to happen? Explainability. Can the court and the parties require an explanation of how the outcome was reached? And do AI systems have the capability to give such explanations? Accountability. If an AI decision or driven or assisted decision is wrong, who is responsible? The developer, the arbitration institution, the human AI arbitrator, who is liable, right? Or who is accountable. And I said under the New York Convention, an award must be rendered by an arbitral tribunal. Does an AI qualify? Right. And if AI is involved, even if a human eventually renders the award, is there irregularity? Those are issues, right? And then I said the broader risk is not limited to AI. There's the risk of data privacy. Every ODR platform will handle sensitive personal data. And so it raises compliance issues. Compliance under the GDPR, compliance under the Nigeria Data Protection Act. These are not optional, they are mandatory. How about cybersecurity issues? Confidentiality is a professional duty of lawyers to clients, whether it's litigation or it's arbitration. How secure are the ODR platforms? especially in the intelligence age, where there are now sophisticated tools that can hack into platforms. How about the cross-border data issues? Because the ODR platform will, operate across jurisdiction, then there are conflicting regulatory environments applicable. Remember, I talked about the EU position. The US position is more flexible. UK is in between. China is state controlled. How do we deal? Right. And then the question of access to justice. This is an ethical issue. If, because we want to resolve issues, we go mainstream ODR, and then we go mainstream AI-powered ODR, what does that do to those who do not have equal access to technology? Yes, there are efficiency gains, but does the ODR come at the cost of excluding those people who do not have access? These are real issues, and I think that there are no ready answers. I said I would end 5:15. Now we are 5:15, but let me land this. What does this mean for you and I? It means that advocacy is changing. If AI systems can now analyze your pleadings or your statement of issues, then you have to be above average. You need new skills, new competencies, right? You cannot be the traditional lawyer anymore. You have to have something that is relevant to the intelligence age. What does this mean? It also presents opportunities. Practitioners who develop expertise in AI assisted processes can position themselves as co-arbitrators. So you might not be the overall arbitrator, but you can sit on a panel of arbitrators because you understand the technology. And like I made reference to you, I represented the country in an arbitration recently. And one of the things the arbitrator asked us was expert opinion in terms of what technology can the tribunal use to transcribe proceedings. I mean, this is then that was 2024, 25. We can definitely not be defaulting to traditional means of transcribing when we have AI tools that can transcribe real time and, give you near perfect transcription. So the arbitrator in that case actually asked, for opinion from us as counsel, understanding that we are experts in technology. So I'm saying that particularly to the young lawyers on this call, right? This is an opportunity for you to develop expertise in not just the substantive part of arbitration, but in the technology that drives this process. And you might just be opening another career path for yourself. I was going to talk about the specific parts, what makes Nigeria unique, but I'm out of time. And then this is a framework for responsible AI adoption. There are 10 of them. Human authority. If AI will assist ODR platforms, the AI must only augment, must never have final authority. There must be a human in the loop, and not just in the loop, the human must be accountable. And you would see that this is a recommended framework. There are 10 of them. I think if we adopt these frameworks, we will be able to make the most of this technology, and then we will solve the problems that are unique to Nigeria. 200,000 case backlogs of cases, access to justice problems, frustration with the justice system. I think we have an opportunity to leapfrog with ODR as a technology powered by AI to solve the justice problem. This is my very last slide. And essentially, I am saying The question is not whether AI will play a role in dispute resolution in ODR. The real question is whether you on this call are prepared for it. Thank you very much. Back to you, moderator. Back to you, Kelvin, if you can hear me. Thank you, thank you, thank you. All right, it appears.
Thank you,
Okay.
Mr. Rotimi. I'm here with you. I struggle
Thank you.
to unmute myself.
No worries. Thank you.
All right. Thank you very much for this insightful session. It was is it 60 minutes, over 60 minutes well spent? Thank you very much. I know we are supposed to convert this to money. I don't know how much we would have paid you at this point because you are going to be charging per minute or per hour. So thank you very much for this insightful session. And also the fact that everything that we are doing right now is actually tilting towards the online medium. So it's something that everybody needs to actually take caution of. This is very insightful, and I can see some comments. Thank you very much. Do we have room for question or any comment or contribution? We just have 2 minutes or one to do that.
Yeah, Mr. Kevin.
Yes.
Yes. Thank you, Mr. Rotimi, for a very beautiful session. Taking a cue on this from almost a summary of the presentation, most especially in the area of mediation, which is more party-driven, and these days where you have a lot of ODR cases that are mediation-related. AI in itself, can it really be a tool that can be employed because you are a mediator, you're neutral, and you're supposed to guide the parties? So how do you embrace AI in getting solutions to them? Being an arbitrator is a different thing, but being a mediator, I see a bit of difficulty. I don't know if you can help or enlighten.
Fantastic question, sir. Fantastic question. Fantastic question. So there was a part in my presentation where I actually went through about 8 different areas where AI-driven ADR can help in the ADR process. One of it, and I think specifically my number 5, was mediator augmentation. Mediator augmentation. So in that case, if you were using an AI or an ODR tool powered by AI in a mediation scenario, first of all, we are neutral, understood. We are all humans. Imagine, and I'm just going to use a very emotional example. Imagine a marital situation, let's say, and I'm a lady, right? I think there's an emotional part of me, if I am not well regulated, if I'm a lady, that may just want to empathize more with the lady as a party. And it will be good if I understand that truly I could be biased. Now, imagine if I have an AI tool and I use a simple prompt and I say, I'm going to be mediating this situation. I'm a neutral. I'm not taking sides. And I really want to distill the issues. Let's do this together. Watch out for my blind spots. That's areas where I may be biased, and flag the blind spots. Now, notice in this case, it's mediator augmentation. I'm using the tool to help my own weakness. And at the end of the day, I may be able to see things more clearly and resolve the issue in a more neutral manner than I would have done if I did not have a tool to assist me. So I don't know. I mean, I just use a very simple example as AI as a mediator augmentation tool and not as an arbitral award decider or any of that. Maybe I should put that slide back up screen. Right. But I don't know if that was helpful in any way, sir.
Yeah, thank you. You see, the thing about mediation is that you're listening and you are helping them.
Yes.
And then you don't enforce anything. You don't tell them do this or do that. And when you even have a breakout session, maybe you could then try to have more of one-on-one. But generally, you're not supposed to be a decision maker. It's for them.
Understood.
Yeah, and so how do you really
I get you, sir.
yeah.
So you use the tool to play that exact role you just described, right? So for instance, one of the things you want to do as a mediator is to help both parties see something on the other side's case, let's use that word, that they are not seeing, right? So
Okay.
yes. So you use the tool to help you, even you. So you are not saying this to them. You use the tool to help you identify areas of agreement that they may not even have seen or known or be aware of. And you are fulfilling your role.
Yeah.
It's almost as simple as that. And
Yeah.
because this tool is it's a pattern, it's a pattern recognizer. Let me use that word. It recognizes patterns, right? So it will see things that humans do not see. So even you as the mediator, you are listening. You are listening. But part of why you are listening is you want to see common ground between both parties, right? And you may see
Yeah.
one or two. But if you subject it to a tool that is completely dispassionate, the tool may help you identify three more that you would not have seen. So that's how the tool can help you.
Yeah, I get it now. Thank you.
Oh, absolutely. I saw
Yeah.
a hand up. I think the hand has been raised. I'm saying this because I think Kelvin was kicked out of the call. So if
No,
that
I
was you,
wasn't.
please. Oh,
No, I
okay,
wasn't.
okay. Sorry. I saw Kelvin left on my dashboard.
No.
Sorry.
All right. Thank you. Thank you once again. Yes, I agree with you, Rosemary. This session is detailed even to a layman. I mean, is visible to the blind, I see. So thank you very much, Mr. Rotimi Ogunyemi. Thank you very, very, very much. I mean, a million thank you is probably not enough to say thank you. Right. So we thank you very much for this session. And I believe that not only me, but every member of this academy and this class would say they've taken one or two things out of this today's session. And I say very big thank you on behalf of the organizers and the committee that actually put this together. We say big thank you. I'm going to get a formal thank you from our chief convener later
I'm
on.
so sorry to interrupt you, Kelvin. I'm so sorry. I'm so
Yeah.
sorry. I think I see a barrister Juliet. Maybe in a minute. Let's just quickly accommodate her and then we close this, please.
Okay, Barrister Juliet, please just go quickly, 1 minute, ask your question.
Yeah, good evening, everyone. Thank you so much for this insightful section. I really learned a lot. I don't know where I would have picked up or know anything about ADR, the ODR. So my question is, maybe if somebody wants to transition, or do somebody have like a specialty on ADR, or it has to be like maybe you're a mediator or you are an arbitrator, or it's a special kind of let me say is its own specialty on its own.
Thank you, Barrister Juliet. Fantastic question, and I'll answer it very quickly. So the short answer is no, it is not a specialty on its own. That's the short answer. But if you go back to my earlier definition, right, I said ODR is just simply taking everything you know or you do in ADR and you take it online, or you take it into a technology ecosystem. So there's no specialty, but Juliet, you can create that specialty for yourself, right? And that was the last thing I said, which is wherever you play already, mediation, arbitration, however you play, you now intentionally decide that you want to self-learn what online tool, what technology tool, what AI tool plays in this space, then marry the two together, you'd have created something for yourself. By the way, there is beyond the arbitration and the act, right, that regulates ADR in Nigeria. There is no regulation, there's nothing specifically that regulates ODR. So you might decide to champion that. Why don't we enter from a policy point of view and create a niche in that space? So I'm saying you are thinking right, drive the space. It's for anybody to embrace. And let me quickly add that. So yes, all the arbitration, mediation bodies are now coming up with rules, right? But I just said at a national level, there's no legislation, and it might be worth championing. So let me quickly clarify that. Thank you very much. Back to you, Kelvin, and thank you for accommodating that.
All right. Thank you very much, Mr. Rotimi. Thank you for your your detailed explanation. Sorry about that. Okay, Nanchang, I hope I pronounced your name properly. Please, do you have a question? Please, can you do that in about a minute?
Yes, please. Thank you. Thank you so much for this, Mr. Rotimi, for that wonderful, enlightening session. Thank you so much. My question is, some of these platforms, ODR platforms that you have mentioned, do we have some that I don't know if we have some that are customized to take into cognizance Nigerian situations, just like some of the law reports, the AI tools for law reports that Nigerian cases and, are built into. Do we have those that are customized for Nigerian use and African use? And then if there are, for a younger practitioner, I don't know whether it's something that can be affordable, to use for people who may want to get it, at the moment. So that
Thank
is
you.
one. That's one. Then the second one is, assuming, let's say you want to, as an ADR organization, you want to promote the use of ODR. Are there recommended platforms that you can say maybe include in your rules to say, if we are going to be using ODR, we are going to be using this particular platform, or is Zoom just sufficient for that purpose?
Fantastic questions, Nanchang. So to your first question, yes, there are some emerging platforms. They are nowhere at the scale of what I just described in terms of the American Arbitration Association's AI arbitration, nothing close to that. But there are some small claims, almost pilot phase platforms emerging in Nigeria. What I'm going to do is, because I don't have them at my fingertips, I'm going to share the links with the organizers, and I would ask them to circulate to everyone on this call. To your second question, of course, Zoom is a second generation ODR platform, right? And Zoom works. I mentioned that I was counsel in an ADR matter recently, and I use Zoom. It worked. It's low bandwidth. It's fantastic. But when we talk about generation three, that is the AI-driven ADR ODR platforms. They are all still emerging. There's none yet that is African or Nigerian specific that we can recommend. And by the way, and this is just me chipping in one more thing. When you come to the AI tools beyond ODR, it is good that we are having Nigerian and tuned tools, fine-tuned to Nigerian case law, Nigerian statutes, and Nigerian realities. But let me urge you that first of all of those tools are built on the frontier models. And none of those Nigerian fine-tuned tools are as smart or as capable as the frontier models. So while for safety, privacy reasons, I encourage you to use the Nigerian specialized legal AI tools, I would also ask you not to discard the frontier models. Otherwise, you might just be shortchanging yourself. But when you use them with a mindset of safety and privacy in mind. That's a separate conversation. I just thought to throw that in. Zoom is fine, but there are emerging tools, and I would share some of them with the organizers. Thank you very much.
Okay, yes, the second question are asked you in case you want to acquire some of these, maybe some of the tools, guidance as to maybe pricing, how to get it.
Yeah, those are the things I will share. Sorry, I didn't go into that detail. When I share it, I will share it as a table form with recommended prices and all. We have just a few seconds here, so I didn't go into that, but I got the question. All right.
Thank you. Thank you.
All right.
You're welcome.
Thank you once again, our speaker for today, and thank you for all the participants for engaging. I'm sure, Mr. Rotimi, you can see that our class is not an ordinary class.
Good evening. Hey, Mr. Kelvin, I have a question.
Okay, please go ahead. Go ahead, Ifoma.
Okay. Good evening, everyone. My name is Ifoma. I'm a 400 level law student at the University of Lagos. So my question is this: how can legal practitioners use AI responsibly without becoming so dependent on it that do not affect their own legal reasoning and their professional judgment? That is, how can they use it in a way that they will not become too over reliant on it? So that's
fantastic question, Ifoma. And for the benefit of you, students, and everyone, let me say this: that in the intelligence age, the one thing that will stand you out is your human judgment. It's your human capabilities, your ability to think, to bring your experience, your lived experience into every situation. Now, the AI will do what it can do well: pattern recognition, predictive simulation. It will try to simulate you and all. But the depth of knowledge that you have cannot be simulated by AI, no matter how advanced. So what I'm saying is, if you are a researcher at heart, Ifoma, an AI would only make you a better researcher. How? You are asking the right questions, and that's what makes you human, right? Knowing how to ask the right questions. What's the gap in this area of law, in this area of human endeavor that needs answers? Then you use the AI as a research tool, not as an answer engine. The AI can help you surface all the research paper or work that has been done in that space in 2025, 24, 23 from all over the world. Now, if you are lazy and that's not you, former, or if you are over reliant on a tool, what you will do is to ask the AI to summarize all that research work. I beg you, don't do that. What you must do is to read all of the research work. The AI has done its part by helping you surface all the research work, which is typically the challenge to most students. I can't find papers. I can't find research work on this. The AI will help you. Then you must read. You must read. I cannot overemphasize that, because as good as the AI tools are, and some of them are PhD level, and I'm not joking, right? They still hallucinate because that's how they are built by design. What will stand you out is when the AI gives you 10 points, you can see that 9 are correct because you read, right? And 1 is wrong. That's what will stand you out, and that's what would make you not over rely on a tool, right? So everything I've said now applies to whatever situation anybody is, whether it's in the ODR we spoke about, or whether it's in your studies as a student. At your core, be the best in whatever you do. Seek depth. Then the tool will help you become a better person. I hope that answers your question, Ifom.
Yes, sir. Yes, sir. Thank you so much, sir. Thank you.
Thank you very much. And right now we cannot take any more questions. I believe that we've exhausted our time and we've gone past our scheduled time. So thank you once again, Mr. Rotimi. Thank you very much. And so for all our participants, we are going to get recordings for this session for us to listen over and over again. And we're going to get it latest by Monday, and then we can prepare for our next class. And I believe we're going to have a beautiful weekend. Thank you once again. On behalf of our
Thank
convener,
you.
thank you once again, and have a beautiful weekend.